Okay, so
Because petitioner will be
we
seeking
need
for
the order
order.
to see what
Absolutely,
the
my
High Court has said.
Absolutely, my lord.
Since we note that the order impugned is not available, since it is stated that the order has not been uploaded by the High Court. List this petition after 2 weeks. In the meanwhile, if the copy is secured, the same be filed in the registry until the next date of hearing. The order dated
6/9/20.
6/9/2023, which was subsisting before the High Court, to continue.
I am obliged, Lordship. Deeply obliged.
Yes, 33.
Make these. I beg to appear for the petitioner with the
Yes.
greatest respect, Malad.
Any other similar petitions? No.
Malad, in one matter, the other party, Malad, who had applied for release was granted. SLP, the state came up in SLP was dismissed.
But actually, who are you in this proceeding? What are you?
I'm an industry, Malad. I'm a manufacturing industry, Malad. I'm identically placed to the other 5 whose lands have been released. And I put that in the form of a map. I specifically urged that point before the High Court. The High Court distinguishes it, Malad, on 2 grounds. One is, Malad, that in that case they had filed objections under 5A, which in my respectful submission, Malad, is not relevant at all to consider whether you should release an acquisition under 48 or not.
Which is the factory premises existing there? Some factory premises?
That's correct, Malad. United Oil Mills Machinery and Spares. Your Lordship, see, my factory has been in operation from 1968, Malad, page 35. So it is factory, and Malad, it is appurtenant land.
Is it some?
Yes.
Photograph or something available to show?
Yes, you've got photographs, Malad. I've got a map. I've annexed the map, Malad, showing the entire thing. Yeah. This is there is a detailed map, Malad, which is almost drawn to scale, which is at page 34. But it will be difficult to open, Malad. May I hand it over?
If there is building which you... No, not this, just to know the
There's a certificate, Malad, that
type of building that is there.
yes, Malad, there is a building, and Malad, there is appurtenant land. But the building can't really function because we are making heavy
No,
machinery.
because what we
Now-
see is notification
Now,
of
what is
88.
your prayer on the petition?
Sorry, Malad.
What is your prayer on the petition?
My prayer is, Malad, that you have already released lands belonging to similarly.
No, but that is a matter to be considered by the authority.
That's correct,
And
Malad.
if
The
you
authority,
know what
the,
it be
the
or
authority
somebody
has
is a position-
considered it, Malad, on totally wrong grounds.
But that is not your prayer.
No,
Why
no,
you
Malad.
say
I-
it
No,
was-
no, no. No, before the High Court, Malad, I have categorically urged that. Please kindly see, Malad.
How is it that it should be considered by the High Court?
Yes, Malad. Kindly see, Malad.
Yes, please take us to.
Yes, if your Lordship would be pleased to have, Malad, page 8.
Page
Yes.
8.
Yeah, your Lordship wants to see the Google map, Malad. Justice Bopanna, I think, wanted to see it.
No, we just wanted to see whether there is a building. at
Yes, yes.
238.
238. Page 238, your Lordship will get the Google map. Now, kindly see, Malad, how the High Court, Malad. Please see page 8, Malad.
Yes,
Learned see paragraph 10, Malad. Does your Lordship have that?
yes.
Yes. Learned senior counsel for the petitioner has vehemently argued that when the respondent is concerned, had in respect of
You have to
entities.
invoke 48B, then probably then they would have passed an order. Now, before the High Court, you later challenge the accused proceeding, number 1. Then you modify it saying that you entered for belief into 24(2). On both grounds, you don't have a case. Now you are incidentally you are raised a plea saying that.
No, it's not incidental, Malad. Before the High Court, Malad's detailed affidavit was filed, written submissions were filed, urging the point under 48.
24(2).
It is filed, Malad.
24(2) you may not have.
No, 24(2), Malad, I am not pressing. Your Lordship is absolutely right, I am not pressing. I have not even raised that ground, Malad, before your Lordship. So 24(2) is a misconceived ground which was taken. Kindly see page 8, Malad. I have specifically given details with regard to 4 identical industries, Malad, in this particular area, where they released on the ground that we don't want to hurt industries because ultimately, Malas, the acquisition was for the purposes of an industrial estate.
Take notice and we'll find out. That's all. But no.
From 1992.
Issue notice to the
It's at 136.
respondent. In the meanwhile, the status quo existing as on today to be maintained.
Yes, my lords.
34.
Yeah, my lords, in a 482, there is almost a mini trial. Where I buy a machine, the machine is for one particular purpose. If the crucial parts are missing, and they say that
You already approached the consumer forum. What happened to that?
that is still pending, my lords.
Pursue that.
But they, my lords, when
Because it
companies
also takes
missell,
more.
companies are definitely deceitful, to say the least. My lords, there is both criminality as well as an action for damages.
Buyer,
Action for
buyer beware.
by caveat emptor, my lords, is the principle. But even caveat emptor, my lords, if I buy a knife, I'm assumed to it is assumed that it is a sharp one. Now, without an edge, said no, the edge is not.
No, that depends on the purpose for what you buy.
Yes, I'm a
If it's for
surgeon.
vegetables, it's a different.
I'm a surgeon.
Perfect.
I am a surgeon.
Oh.
This is the basic laser machine, my lords.
We don't think so. Sorry.
Not a case. Having the limits in.
Obliged.
We see no reason to indicate, but we should disposed of. S35,
My lord, 35 is to be
Your lords,
coming out of the food scam.
tag it. Notice.
your lords, jalebi condoon. Your lords, jalebi condoon.
Notice tag along with SLP criminal D number 33627 of 2022.
Obliged.
Plus, I'm appearing in 36 minutes. Plus, it is a case where I was the bank manager. This pertains to allegations of year 1999 minutes. I've been convicted for 2 years minutes. He made a very detailed argument submission. In fact, from para 43 to 53 minutes, we'll see the MP on nothing has been considered minutes. The allegation, insofar as I'm concerned, is that I have not verified the ITR returns given by A1, A2, sale deeds.
What happened? You have been dismissed now.
I'm so sorry.
You have been dismissed now.
What happened? Inquiry was conducted as against me. Penalty of reduction pay scale by 4 stages was passed as against me. The departmental inquiry came to a clear conclusion. There was no criminal.
6.1.
Issue notice to the respondent. In the meanwhile,
raise that, make an attempt. Lord. The last point is, Lord, your lordships from Baliram onwards have always maintained that a court should not hazard a risk of comparing handwriting. Both the courts here, the trial. I'm not saying, therefore the hazard the risk in the sense that when there is a holographic will, then it becomes a matter of expertise, Lord, that when you are comparing two signatures,
Not in civil matter.
which in this case, the court,
Evidence that confers power on the court. Yes.
I'm not disputing the power, Lord, I'm just saying the court ought to have.
Dismissed.
25.
Facts.
I'm 25.
Item 20.
Yes.
And for the petitioner, the original plaintiff, what has happened in this case is that a trial court has come to a finding completely in my favor. He appreciates each and every evidence on record. What High Court does is completely upside down the whole judgment, without any basis of any evidence. Plus, I'll just explain you the case in a nutshell. Plus, what happens is that the plaintiff is the son of the first wife of the deceased. His father is murdered in 1954. In 1950, apparently, there is some nominal settlement deed, which is the settlement deed giving the rights of the parties.
You're issuing notice.
Notice. But then stay of the what is happening is that my the subject property is not protected.
No.
They're trying to sell out the subject property.
Pending appeal before the High Court, what was there any interim order?
No minutes. But I think there was one. I'll just check up.
Let the other one.
We've given notice, that's good enough. Yes.
Please. Obliged.
Please, Your Lordship, this is the contempt petition.
What is the violation?
Lordship, may kindly see the order. Lordship, may kindly see the page 15 and 16. Lordship has specifically directed for the continuity of the service with all consequential benefits. And see the page number 35, how they have acted. So I will read
Without back
page
wages.
15. Huh?
Without back wages.
No, I'm not claiming back wages, but continuity of the service. I have joined in 2015. They have considered.
They are not.
Lordship, kindly see page 15 for a moment. From bottom, I will read 2 paragraphs. I will read and then I will go to the page 35. Shall I read page 15? Taking into consideration the material on record on the first date of hearing, when the matter came up on 11th of March 2022, while issuing notice, this court passed a stay order directing the respondents to restore the petitioner on the post which he was holding on the date of termination, that is 19/10/2016. Pursuant to the interim order dated so and so, the petitioner was reinstated on the post of Scientist B, wherein he joined on 14th July 2022 in the regular pay scale. After we have heard learned counsel for the parties and taking into consideration the material on record, the joining of the petitioner on the post of Scientist B is made absolute with the further direction that he will be entitled for continuity of service with all consequential benefits. So I appointed in 2015. There is a merger of NIMH into the ICMR in 2019. During the merger, they have considered all the posts on the similar post and on the same payroll. So those orders I have also annexed. So now see page number 35. After filing of this contempt,
10 service rendered in any other shall not be considered counting the.
earlier I was working with NIMH. I have been transferred to the ICMR.
Okay, let a copy of the petition be served upon the alleged contemnor.
Yes, sir.
Let a copy of the petition be served upon the alleged contemnors.
I don't have their residential address. Official address I will serve them because I'm not able
Whatever
to.
address you have
Yes,
proposed, I think.
yes.
Because what you are,
Yes. This is a
the
clear
grievance
contempt.
is their action in official capacity only.
Yes, yes.
Least after 3 weeks.
Any specific date? Because-
Date, given all these holidays, we lose track of the date.
Yes. I'm obliged.
27.
I'm for giving.
Please, Your Lordship. Your Lordship, kindly see the very importance whether that plaintiff was present on the last day at the time of registration, which is very crucial. He says before the court, I purchased the stamp papers for registration
This
purpose.
is, again, you are arguing on facts. What is the law point involved? Tell us.
The time is the essence of the contract. Whether
That
the parties was present before the register office on the deadline is an important fact. So the plaintiff says, I was present there. I purchased the stamp papers for registration purpose, but he has not produced it before the court. He has not produced it before court. On that finding, the trial court gave in my favor. That's
Notice is waived so far as the sole respondent is concerned, least after 4 weeks.
My lord, I am praying the stay of the High Court judgment because the High Court says you go in accordance with the law. For
No
registration,
need, will here we should notice.
my lord, they will press it before the trial court. My lord, state formal state.
See to it that the pendency of the matter is respected.
Yes, my lord, otherwise they will, because the High Court.
We are here to correct any course. Yes.
28.
Much. For the petitioner, we have some.
Later.
29.
Right.
Wait. On the present case court, it's a matter of experience, bro. What they proceed to say that after I've acquired my qualification, experience attained after that should only be taken into consideration.
Both
They
the
were-
courts have appreciated your arguments.
What it has not been because subsequent to the same chair,
Single bench and division bench, both.
but they have not at all.
It was interpretation of Rule 10.
Or there, kindly see the rules followed and kindly see the two judgments of this court on the same lines followed. That has not at all been adverted to. And they also accede to this fact followed. They what they do in 2015, they pass a resolution also. And
Now much water has flown.
and 2000, what my contention has been that has been accepted in 2021. Then they make a specific amendment. But the appointments were subject to the result of the repetition in question. So it still survives, my lord. That is my submission.
It was a matter of 2007.
And the rules of the game has been
2007, we are in 2023.
like 2000. It's not 2007, my lord. It's 2014. 2014, my lord. And the rules of the
Almost 9 years.
but the rules of the game has been changed midway. They accept this fact.
But now the latest view possibly it can be changed midway.
No, not that one. What they
It has been referred to a larger bench.
it has been referred to a larger bench, my lord. That is there. So your worship issue notice, my lord, and then
No. Nothing.
what you are
Don't give false hopes to the
What-
petitioner.
what it's
Dismiss.
False hopes.
what I had
After 10 years, nothing can be done.
what it was subject to decision of repetition in question. And there are vacancies in question. Or there is no question of giving any false hope. What I am submitting with respect that once I was eligible, I was in the constitutional zone, I was selected. On account of this experience, they have not suited me. Kindly visualize or not. And in the year 2015, they proceed to issue a letter. They pass a resolution that this would be our view. In 2021, they amend the rules. Kindly see on the rules in question that is existed on the date of the election or not, that would apply to my case. And as for the same, I was duly qualified.
You were not found eligible on that.
But that is the wrong perception that they have proceeded to carry. Kindly have Rule 10 for a moment.
What the courts have appreciated.
Sorry, ma'am.
Or kindly have Rule 10 for a moment. It does not say what they are saying.
Courts have already explained.
What your lordship, kindly see the person has been litigating. She has been vigilant. Kindly see the vacancies are still there. No further selection has been made till date. Kindly visualize our plight also, my lord.
You should have tried somewhere else also. You can't just rely on this. petition.
What this can be suggested at all point of time. The fact of the matter is that here she was in the select list. She was in the merit.
Anyway, we are not interfering with current. Yes. Next matter.
But only by 1 month she was missing, and that too the experience was there. What your lordship knows, my lord, that there are institutions wherein the moment examinations are over, there is campus selection.
According to you, the declaration of result was not in your hand.
No, that is true. That is also one of the
That
facets.
was your.
That is one of the facets of the matter.
The fact remains that there was
Modest-
some short of some days
More this day.
or months.
What here what happened, my lord, the moment examinations were over, there was campus selection. All those experiences are there. That makes 3 years. And what they have computed 2 years, 11 months. Can you visualize from that perspective, my lord? It's a very hard case. This lady, my lord, she has been.
Other candidates.
Vacancies are still there. Or the state can very well come and say they are. Or they,
For those vacancies also, other claimants would be there.
no, there are no claimants, my lord.
10 years.
Or it's not, your lordship, kindly visualize the matter has been going, we have no control over the court. Not your lordship, but we have been pursuing our matters diligently. And there are vacancies in question. No further selection has taken place. Kindly visualize from that perspective. And the rules, my lord, what we are submitting in 2021, they amend their rules in the same line.
That's okay, that whether improves your case or. Actually.
But at the point of time, the rules in question have been wrongly read and interpreted. That is my submission. And there are 2 Supreme Court judgment which we have cited in the synopsis in question.
Litigation must come to an end.
But it should come to its logical conclusion, my lord, for the simple reason that in case some wrong has been done, that should be remedied, my lord. That is my precise submission.
There is always a gulf of, what should be and.
Or because the vacancies are, what I have been insisting for one simple reason, the vacancies are there. No further selection has taken place. Kindly visualize from that. Kindly visualize from that perspective, my lord.
Sorry, yes, next matter.
As lordship.
30.
My lords, this is a modification application.
No, for extension of surrender.
But it does not require any further adjudication, as the FIR itself was passed on 27th last month. But there is one.
Withdraw this.
Withdraw this.
I will withdraw. Yes, only one problem is there, that while disposing of while dismissing the writ petition, there was an order direction for the refund of the bank guarantee.
Dismissing or allowing? You said that the FIR has been quashed.
No, my lords, regarding Annexure 1, that is the order dated 18th of August 2023, when our petition was dismissed before this honorable court, there was a direction for refund of the bank guarantee. So the thing is that it was a bank deposit rate of 5 lakh rupees. So instead that word may be included, modified to that extent, or maybe a direction may be given.
Which order are you referring to? Which order are you referring to?
18th of August.
18th of August doesn't speak
See,
about-
right now we won't interfere. I mean, only thing your prayer was for extending the time.
Yes, my lord.
We can't address any other question. The matter has been
My lords,
disposed
the
of.
only thing is that instead of bank guarantee word,
See, we can't modify that part of the order. Yes.
then in that situation, my lords, I will have again to file, because the Gujarat
If
High
you
Court
have
is not refunding that amount.
If you
Because
have to
they-
file, you file.
My lords, they are saying that bank guarantee word is there and you have deposited bank deposit is there of rupees 5 lakh. So where is the word bank deposit written in the order?
So where have you
This is the
stated
problem.
that? In this petition?
It is on page number 10.
No. In this
Page-
petition which
Yes,
you have
yes,
made,
yes, my lords, in page number 10.
what are your prayers?
My prayer is regarding only enlargement of time.
Yes, then
As far as the modification application is concerned.
then how can we take into account any other factor in the
My
disposal
lords,
of matter?
mistake by the earlier
That
council.
The court has already granted you the liberty to approach the High Court.
High Court, but the High Court is saying that since the order
High
mentions
Court means you have to
bank
file-
guarantee.
No, saying it means there has to be some order.
My lords.
You have to approach the High Court and pass some order. You can't say High Court is saying.
No, we applied there.
Applied means what?
Information.
This is not before us.
The registrar for the
Not registrar. You file the appropriate proceedings in the High Court.
Learned advocate appearing.
May I just clarify, because I'm again unable to express the correct position.
Yes, because your petition doesn't express that.
My lords, definitely.
Only petition is for extending time.
Petition, this modification application was only filed for in
That was
enlargement
not
of
your
time.
prayer, it is idea also. What you are saying is not your prayer even.
Definitely.
Then how shall we leave?
I'm just praying.
How shall
my
we-
lords may accommodate me on this point, that instead of the word bank guarantee, my
No.
deposit may be
Fine,
refunded.
appropriate idea means.
The learned advocate for the petitioner submits that the present application has become infructuous stuff. Hence, the present petition is dismissed. Dismissed as withdrawn.
That's withdrawn.
31, item 31, I had instructions to withdraw this.
My lords,
petition
a
as-
liberty may be granted for the refund of the bank.
Why liberty? It's a disposal of matter. We have become functus officio. It can't give any liberty.
Item 31. I circulated a letter. I have instructions to withdraw this petition.
Learned advocate for the petitioner submits that she has instruction not to proceed with this matter. The present petition is dismissed as withdrawn.
No. 32.
All that, yes. Because this is a matter where there is an agreement to sell. I paid the full money.
No, these are the proceedings on the pregnancy you have challenged. And you have also filed other proceedings in other forums. So the High Court has said that you pursue those litigation.
You know, the full money I have paid, the documents are
Not
here.
the issue.
And then
High Court has given you
How can you challenge, file writ petition for the proceedings under 13(2)? When you have already filed proceedings under Surface Act before the other forum.
Mr. Parekh, might be better for you to withdraw the petition.
You may pursue the other remedies.
yes, Milos, I'll withdraw it and Milos, kindly protect me for my rights, whatever I am.
No, that has already been protected by the High Court.
But now that I have come to the lordship, it is bad for the lordship.
They are not entertaining, so
Mr.
this order will remain.
Parekh, in the senior counsel appearing for the petitioner submits that he has instruction not to proceed with the matter as his client would like to approach the other statutory, other forum for the relief asked for in this petition.
That's
In view of this submission, the present petition is dismissed as withdrawn.
disposed of, your lordship.
It can't be disposed of, the notice has to be issued.
That's.
Yeah, please, Lords. A very limited point of submission.
Limited, you have already been granted 1 year.
I just have one point to.
And your counsel sought time for 1 year. That has been granted. How can you have any grievance?
The petitioner, aged 94, he.
Whatever he
wrote
has to
his case there in two forums, my lord, neither in prescribed
Start with
authority
the age.
nor in the appellate authority.
If I may.
Allow me to show just one thing that has my lord's case, just one thing.
You can't have any grievance. 1 year, we also don't grant 1 year. We grant only 3 months to vacate.
But the matter was not considered that on merit because the restoration application was denied by the lower authority.
Your counsel had sought time to vacate, which has been granted by the court. Matter ends.
But there's just one small thing to say, if I may be allowed. There was merit on part of the tenant because when the matter went to prescribed authority clearly noted that there is no bona fide need proven.
You did not remain
It's
present.
unfortunate,
You
madam.
did not remain present before the appellate forum.
No, not present. Unfortunately,
Anyway, we don't want to become an extension court, yes, dismissed.
as well as.
So,
Poor Lord, there is a letter.
Lord, I must say, this is the strangest type of abuse of process of this honorable court.
Sorry, my lord.
The writ petitioners have already come to this court, civil appeal dismissed, now filing a writ petition, Lord, which is a review, in fact, Lord, they challenge the B.Ed candidates have been appointed long ago. Just because your lordship is a part of it, that's
Have some decorum with great respect.
I'm so
There is a
sorry,
letter
Lord,
I am saying.
you file
We
this.
need to file.
order against you.
Sorry.
At present, there is no order against you.
No, but
They're
they're
asking for time.
Yes.
very well not, but.
And they
You are
are
saying-
even not on caveat. They are just appeared, Lord, just.
Adjourned as per letter.
Very well,
Yes.
very well.
Have you filed caveat?
No,
After
they are
we
not.
find the applications to get ourselves, because it's our appointment that they are, challenging.
It's a review